So, you had an agreement, an oral agreement with your landlord that you will do an innovation on the property, expend your money, perhaps even help you finish the property. And at the end of the day, the money that you expended will be deducted from your rent, or you will stay for a period of time without paying rent. However, your landlord at the end of the day did not owe the end of his bargain. Instead, he gave you the full rent to pay, or even refused to allow you stay in the property. What can you do? Firstly, you were very wrong to have entered into an oral contract with your landlord in that regard, in that you should have allowed a lawyer, or at least anybody, draft an agreement between you and your landlord. You should have put it in writing anyhow whatsoever. It should have been evidenced in writing so that you have proof, because at this point in time it is your word against his. We know that at this time you are already thinking you should start removing your innovation, you should start tearing down the things from the property. However, you are legally not allowed to do so, because if you do so, your landlord can sue you, because any innovation done on the property now becomes part of the demise property, and by so doing, tampering with it is already tampering with the proprietary rights of the landlord, and that puts you in a very precarious situation. What then can you do? Your only remedy is to take legal action against your landlord and not tear down the property, because if you do so, you have reduced yourself to self-help, and that in itself is an offense against the law. You're only entitled to compensation, which only the court can give to you. Now, what are the things that we're talking about? The innovations that are part of the property, that if you start removing them, you will be tampering with the proprietary right of the landlord. For example, tiles, POP, roofing, anything that is embedded in the body of the property fits into these categories. So, what should you do instead? Before you enter into such contract, ensure it is in writing. I will tell you a story. A few years ago, I had a client who was involved in that, who was in this particular situation. In fact, he had that agreement with the agent of the landlord. However, when the landlord, after he did all the maintenance on the property, and the landlord now heard of it that, oh, this guy will not pay rent for the next 2 years. The landlord said, no, I did not agree to it. And the client cried to me. I was like, beloved, this is the situation I'm in. I took my phone and called the landlord. I had to tell the landlord that if you do this kind of thing, we are going to sue you, and this and that and that. And then the landlord had to calm down. And we now sat down and renegotiated. And that was how my client was able to get a reasonable remedy. In this situation, you can't tear it down. If you do and they sue you, you'll be held liable. You just got that for free. Now, follow for more.